Good morning, everybody, and welcome to this morning's HR Insights. We're going to be discussing third-party harassment and the Employment Rights Act. As you'll all be aware, and no doubt have attended other insights sessions, there are significant changes in employment law coming in over the next 18 months. And one of the things we're seeing increasingly is an obligation in respect of third-party harassment. What we're going to do today is cover the existing law, the changes that are coming, and also practical implications that you may want to consider. I'm joined by Hilary Aldred and Sophie Humphrey. If you do have any questions, then please do pop them in the Q&A chat. There's a bit of time for questions at the end, but of course, if you've got questions, pop them in and we'll deal with them then. So over to you, Sophie.
Good morning, everyone. So, as Gemma mentioned, I'm going to briefly summarise the current legal position in the UK on third-party harassment and an employer's duty. So, just to clarify what we mean by third parties, I'm sure everyone's aware, but just for completeness, we're talking about a wide range of individuals that are not employees. So, customers, clients, contractors, suppliers. In healthcare settings, these would be patients. In education settings, talking about patients and parents and carers, sorry, and just kind of members of the public more broadly. And in many cases, it's kind of client facing and public facing roles that are more at risk of third party harassment. So, historically, protection from harassment by third parties has quite a checkered past in the UK. The law has flip flopped quite significantly. There was a law that was repealed in 2013, and then there was more discussion coming up to 2023, and then third party harassment was omitted from the Worker Protection Act 2023. So previously, the Equality Act actually did contain specific provisions making employers liable for third-party harassment, but only when there had been repeated incidents and the employer had failed to act. And those provisions were actually repealed in October 2013, so it kind of left a gap in protection. Um, as I'm sure we're all familiar with, in October 2024, new measures then came into force to strengthen harassment protections in the workplace. And most notably, these reforms introduced a proactive duty on employers to take reasonable steps to prevent sexual harassment of employees. I'm sure throughout this morning, you're going to hear the phrases reasonable steps and all reasonable steps a lot. Um, Essentially, the reasonable steps duty that came in 2024 is anticipatory in nature. So it means employers are required to think ahead and assess risks, implement preventative measures such as policies, training, reporting mechanisms, etc. And this was a really important shift in emphasis because historically the law in this area has been largely reactive as opposed to being proactive. And employers have mainly been exposed to liability after something has already gone wrong, rather than being required to actively prevent issues from arising in the first place. However, when we're talking about third party harassment, it's really important to be clear about the limits of those October 2024 changes. Um, Although the 2024 preventative duty does extend, at least in regulatory guidance, to risks posed by third parties, such as customers or clients, it doesn't create a new standalone right for employees to bring claims purely based on third party harassment. So there is no automatic statutory liability for third party harassment under UK law as it stands. What this means is an employer is not directly liable under a standalone provision simply because, for example, a customer or a client has said something, harassed an employee, and this means employees cannot bring currently a standalone direct claim against an employer for third party harassment. Um, this is kind of like the key point to emphasize really at the current standing. Unlike harassment by colleagues, where employers are generally vicariously liable, there isn't an equivalent for third party harassment. And instead, the protection comes through the Equality Act. So in practice, an employer might still be liable if their response or a failure to respond to third party conduct amounts to, discrimination or harassment under the Equality Act. But the focus essentially at the moment still shifts away from the harassment of the third part by the third party, sorry, and onto the conduct of the employer itself. And currently, the law kind of looks at what the employer knew about the situation, what steps the employer took, and whether those steps were reasonable. A really helpful way to think about it currently is that the employer is not being held liable for the third party's actions directly, but for its own failure to respond appropriately to a known risk. So if, for example, an employer knew that an employee was being harassed by a client and that employer then failed to take reasonable steps to address it, such as, moving the employee to a different site, putting signage up, words of warning, if it was a supplier or a contractor, for example, investigating that, then that could amount to unlawful harassment in itself. And kind of failures to address third party harassment could also amount to a fundamental breach of contract, resulting in, resignation, claims for constructive unfair dismissal. So, for example, if there were repeated requests by an employee to not continue working with a specific client because that client has subjected them to various forms of harassment, abuse, comments, and an employer didn't take steps to mitigate that risk, that could potentially result in resignation. You could bring a claim for constructive unfair dismissal. But again, it's not a direct claim against the employer for third party harassment. So, what it currently means is even though the harassment is carried out by a third party, the legal focus is shifting and going indirectly through legislation to bring claims in relation to the employer's conduct. So, it kind of creates a gap in that direct liability link. I'm going to pass on to Hilary now, who's going to discuss the upcoming changes to the law in light of the Employment Rights Act 2025.
Okay, thank you very much, Sophie. So, what is the new law? What's changing? In October this year, the provisions of the Employment Rights Act include the change where it's going to introduce a new explicit duty to take all reasonable steps to prevent harassment by third parties. So what does that actually change? By adding the word all to the employer's duty, i.e. you've now got to, or you will have to, take all reasonable steps to prevent harassment of employees, the intention is to strengthen the duty that's already in place. And in reality, it's intended to mirror the concept of what all reasonable steps would be as a defence when we have a defence within the Equality Act as it currently stands. Confusingly, annoyingly, the Act doesn't currently, however, state what steps are going to be reasonable for an employer to take, but there is a mechanism whereby the government are intending to address this gap so that the Act is providing for future regulations to specify what reasonable steps an employer must take and the matters which they must have regard to in order to prevent the harassment. And the government has sought evidence on what steps are effective in reducing or preventing harassment before it's going to enact such regulations. However, we are then left in a slightly weird situation because, confusingly, the regulations, when they are introduced, are likely to only be introduced in 2027. So those who can actually count will work out that we're going to have the obligation to take all reasonable steps to prevent harassment at some point after the duty has been imposed on employers to take these steps. So what does that then mean? Well, if the regulations, and assuming the regulations are enacted, an employer will have taken all reasonable steps where it sets out it takes the steps which are set out in the regulations, as well as it has taken all other preventative steps that it is reasonable for a particular party to take in the particular circumstances. And some of those are things that Sophie has just talked about. So there are examples of steps which may, according to the government, be included in the regulations, like the risk assessments, publishing policies, publishing plans. What are you going to do in respect of reporting and handling complaints? But we are going to have to be a little bit of watch this space because there may well be other examples that come forward as a result of the consultation. For where it is at the moment, it is worth paying attention to the fact that we do already have some existing guidance. So the EHRC does have existing technical guidance which will provide advice on the types of actions you can take to prevent and respond to harassment, including an employer guide. And they are expected to update that further in advance of further duties being enacted. And where is this going to go moving forwards? There are other things that are worth also thinking about that we know are going to come forward. So, for example, we are expecting that there will be a change also about the prevention of non-disclosure agreements, so that provisions in agreements preventing disclosure of harassment and discrimination will be void. There may well be big impacts on things like settlement agreements, confidentiality clauses. Those who are already caught by some other bits of legislation are aware that, for example, in the freedom of speech rules that apply to higher education institutions, there's some stuff on non-disclosure agreements there. But we are looking at where that might impact more generally. And it might mean that you have to have legal advice on what will happen in respect of that. So when does this duty apply? It's going to apply across the board in the course of employment. So when you're at work, when you're on business travel, client meetings, the proverbial Christmas party, where we always get kind of questions as to what does that actually mean? And also anything else that effectively comes in respect of what is somebody doing when they are working. But there is a key shift, because currently there's no standalone liability for harassment by a third party, by a customer, a client, a contractor. And as Sophie was just saying, we have got to try and look at, well, what does this then mean? At the moment, and it's, have you done everything? Have you got the policy? Have you got the process? This act, when it's enforced in October, is going to change this status quo. It's going to make it much, much more proactive, and there'll be no requirement that a single incident is, well, you've taken everything that you could have done. That was a reasonable step. You couldn't have predicted the single incident to trigger liability, because now what we're potentially going to have is a third party who harasses an employee. Means that an employer may not have control. You may not have expected this. It may be a single event, but if you haven't taken all reasonable steps to prevent it, then it will potentially lead to direct liability. And it's really unclear how this is going to come into force and how one should balance the obligations, for example, in respect of freedom of speech, freedom of expression, and where an employer might have a expectation in respect of something. So what does that difference actually mean in practice, and where are the differences? And can we just move the slides on in respect of that? Where are the differences in respect of what is going to happen? The government rejected, as part of their process, quite a lot of the concerns that were being raised about this balance, and saying that third-party conduct which is trivial or causes minor offence shouldn't be enough to trigger, or will not be enough to trigger, liability. Somebody's subjective perception of third party's conduct is offensive is not enough. So again, that's picking up what counts as reasonable steps and what's reasonableness. And it's likely that we will pull in a lot of the practice that we've had in respect of the employer defence, as I mentioned before. But also, you are not, as an employer, going to be penalised for failing to anticipate or predict something that is wholly unforeseeable. So what does that actually mean? It means that you've got to look at what is foreseeable and what are your reasonable steps in respect of third parties. They're clearly going to be more limited than you might be able to take in respect of employees. So you have got to think about taking into account the nature and any contact with third parties, the type of the third party, the frequency, the environment where they're going to come in place, but also any interference with people's freedom of expression, because that's got to be both necessary and proportionate. So what are, therefore, you supposed to do? I think it really is a question of making sure that the policies and documentation, warnings, signage, things along those lines are put in place, that it is important to think about, well, we've known this is coming, and we've already got the duty. So what has actually happened since the first duty was introduced? Has that actually made a difference? It's a good time to put that and review that so that you can actually say, well, we had these policies and documentation. Is that actually enough? Are our warnings doing enough in respect of that? It's one where back in 2024, we were doing quite a lot of training in respect of this duty. Where people haven't been trained, it's worth picking that back up again and trying to work out what one does in respect of that. And it's also the risk assessments. I was talking to a client last week about a actually potentially criminal issue that had arisen, and they were trying to work out what was happening. And I said, well, where's your risk assessment? Have you got a risk assessment? What does this do in respect of the duty to prevent sexual harassment? And despite the fact they're a large and relatively sophisticated client, it was like, yeah, we have got one, but we haven't looked at it since the last time that we were thinking about this back in 2024. So where do we go now? And it's a good opportunity to take some time and say, actually, where are we doing? What are we doing in respect of that? Also, what is happening in respect of reporting? And is there more being said in respect of people speaking up, advocating? Are we challenging people's behavior? Are we banning people, customers, removing third parties? What is actually happening in respect of that? So then finally moving on to what are the possible steps that we think that organizations can now be doing. Most companies we deal with have got anti-harassment policies and they're in place. Most of them do communicate them to staff, but actually, can they prove they've communicated them to staff? We normally suggest that people should be asked to sign a statement to confirm they've read, understood, and will comply with the policy. It's a good opportunity to try to audit that, make sure that is the case. Make sure if you're updating the policy, you get a signature through in respect of where things may be. What are we doing from this stage? Where does this pick up, and are we doing enough? Are there anything that employees want you to do? It's actually probably quite a nice idea to proactively engage with your staff, find out if there are issues in the workplace, whether that's picked up in one-to-ones, 360 reviews, anonymous staff surveys, exit interviews. Do you see anything that you find troubling if you ever look on Glassdoor? I know quite a lot of my clients do sometimes look on Glassdoor to find out what's being said about them anonymously. Have you got the risk assessments to identify potential issues in the workplace? That some people are better than others in respect of risk assessments. Those attendees who are dealing with education might also want to pick it up and make sure it does tally in with safeguarding risk assessments. Does everybody know how to report things? Do everybody actually say what they want to do? And do managers really know how to deal with things, or are things still being put under, like, brushed under a carpet? So is there a reporting system? Is there a way of dealing with it? I have got to say, personally, I take a big issue with whether reporting should be anonymous or not anonymous. I don't think there's a particular right answer. Quite a lot of employers think anonymous reporting is a good idea, and I think it's probably fine if you've thought about which way it would go. But where are the records kept? How are concerns dealt with? Do you know what's being dealt with both formally, but more to the point, do you know anything informally, so you can pick up and address trends? And train staff on what harassment actually is, what they do if they experience it, what they do if they witness it, how they handle any complaints. Because this is about third-party harassment, where businesses will have third-party issues and third-party harassment is more likely. Again, training should make sure that staff know how to deal with that. It should never be allowed to become stale, not be a tick box exercise, and should be ensured to designed to ensure that all staff engage properly with it. So ideally, some kind of interaction, quiz, survey, whatever else it may be, but also make sure that the training is tailored to the individual. So managers know how to spot signs such as absence, lack of participation in team meetings. Is there something else going on that might be a trigger? Is somebody reluctant to work with somebody else? Are they not sure how they're going to deal with things? And make sure everything is updated regularly, scenarios are updated. that they're tailored to any experiences that you've had. Then if you do get a complaint, how do you deal with those? Deal with them promptly. Make sure that you know what you're doing about confidentiality. What are you dealing in respect of that? But for customers, clients, patients, consultants, students, other people, what is the reporting mechanism in high risk workplace? So do you have wording in commercial agreements, in provisions in respect of people coming onto your site? Do you have signs when someone signs in to come onto your site? Do you have the proverbial notice up in the bar or the restaurant to say such things aren't going to be tolerated? But the other thing that really is an issue at this stage is making sure that people know that you are actually monitoring and evaluating what's happened before. And those employers who did do something in respect of the original duty, it's a really good time and a really good chance to monitor and evaluate what's happened already. And is there anything else you could have done, should have done, would have done differently in respect of what had happened before? Those who can afford to, who are large enough to, it's also worth thinking about, can you do anything to support employees? Have you got counselling in place? Are you actually making sure that there is something that employees are supported if they're going to say something and they're not frightened to raise complaints that may have some merit to them? So I think that's really where we're at the moment. And then it's also one where I know Gemma was potentially going to come in and say something about, are there places where there are higher risks in respect of this? And are there things we should think about as regards, does something about the working environment make the situation harder? Are there power imbalances? Are there culture issues? Is there stuff to do with job insecurity? Is it something to do with agency staff, contractors, lone working, people left alone with customers, alcohol, the proverbial Christmas party back again? Are there always non-alcoholic drinks available? What's happening? What do we do about staff travel? Where are managers actually dealing with it? What happens if they can comply with their management responsibilities and immediately step in? Is there a risk if you're moving one of your employees to another site? Do they go and visit lots of customers? Are they on secondment? Are they working from home? Is there something that's happening virtually? Don't just assume that the steps are in a physical building. What is happening at things to do with social media? I get so many complaints about social media and harassment, again, largely in education providers, but across the board. And also, are there places where there's more than one protected characteristic, which may also mean that there are higher risks in respect of that? So once you've thought about that, then it really is a case of, well, what can you do after then? And that is the point I think Gemma's going to come and say something.
Well, thanks, Hilary. And in fact, some of the points I'm going to make are actually covered in the questions that we have been raised. One of the questions relates to, does it apply to students and pupils? And it will do. I've had a case recently with a school client where a pupil made comments that were wholly inappropriate and would amount to sexual harassment. And of course, the point here is, as an employer, you can't legislate for what the third parties do. What you have to do is be seen to be taking steps to limit the risk of that third party harassment. And I think how I can identify potentially what's changed is the school policies in respect of third party harassment and behaviours as a student hadn't hugely changed. They had done some more training in respect of pupils around what is harassment, the appropriate behaviour standards. But I think these changes in the law require the school to take action against the pupil. So historically, and even at this occasion actually, there was a slight reluctance to take disciplinary action against the pupil on the basis that actually did the pupil understand what they were saying. But of course, what this change in the law effectively means is, can you say you're taking all reasonable steps if you aren't addressing that as a disciplinary issue? Does the student really understand what they've done wrong? And what type of what type of message are you sending to other pupils in that regard. And I think that's really important. Equally, and Sophie, Hilary, you may want to cover on this question off. We've had a question around reasonable steps in respect of work events, which I think is going to be a significant issue, because again, it's going to your point, Hilary, it's the type of environment where there's likely to be drink. Boundaries are likely to be lifted. People are likely to be working on the basis it's not really work. I've got some thoughts on this, but I suspect that Sophie, Hilary, one of you may have too.
And I think it's one where it depends entirely on the context, which is always the difficulty in respect of that, where does work start, where does work end? And there's been quite a lot of case law over that going back, certainly as long as I've been practicing, as regards what does happen. But it is that thing whereby if you are extending into an evening, if you're extending, it probably is work. If it's genuinely independent, it may not be, but it's always fact specific. And I don't think this is supposed to be a charter of nobody's supposed to go out, socialize, have fun, whatever else it may be. However, it's where do the boundaries go? And I think it's providing more clarity that actually what's unacceptable in a workplace is probably unacceptable generally. I have got to say that actually, if you're thinking about it, that none of us really go anywhere expecting to be harassed, called rude names, whatever else it might be in respect of that. And I think that that's just a general standard of behaviour, and that this is trying to probably improve general standards of behaviour across the board. But if you wouldn't do it in the office and you wouldn't do it anywhere else, why would you do it just because you're somewhere else? Is sort of, I think it's a general, we are trying to do enough. This is not supposed to be a charter whereby a single one-off offence that you can't predict is prevented. But actually, it's foreseeable if someone says something that's harassing in a pub or in a club or at a training event, that might cause somebody offence. So I'm of the view, well, we just need to encourage people to behave better. But maybe that's naive.
I think there's also a point on that where if the event is quite clearly, a pub or off-site somewhere where you're going to be exposed to more third parties than you would if the event was being held on site and you potentially had catering staff in and that kind of thing. Regardless, it goes both ways. But I think the messaging could be quite clear that it's optional to attend these type of events, particularly if they're a social type of thing. It's no obligation to have to drink, particularly. If it's a networking event, that's slightly different. A lot of jobs have the obligation to go to those events. But I think if risk assessments are going to be done, for example, the risk assessment for a work party, offsite or work Christmas do might be quite different to that of a networking event or traveling abroad for an event, for example. So I think it's really going to depend on the circumstances, who's going, the amount of people that are going, who the other attendees are going to be, where the venue is. So it's lots of moving factors.
And I think just on that, it's really important that as an employer, you're prepared to say to individuals, as in third parties, you cannot attend. So we've had a case recently with, it wasn't a work event, well, it was a work event, but not in the social context. It was a exhibition. Client was sending employees there. The female employees were all saying quite clearly, if this person comes to the stand, can you, male employee, deal with him because he's slightly lecherous, albeit harmless, query if harmless is right in that scenario, but their view was it just makes us feel a little bit uncomfortable. And the male manager in that scenario said, yeah, that's fine, I'll deal with him. But of course, as inherently happens in these scenarios, the male manager was speaking to somebody else when this individual rocked up to the stand. And in that situation, there was a whole big discussion that I was involved in around, well, actually, what could we have done differently? Because in my view is if you've got management and other staff that are fully aware of this risk, you should be prepared to say potentially to their employer, actually, we've got concerns around their behaviour, because that's going to be something that you're potentially exposing your staff to that you are potentially fully aware could amount to harassment. So there is that obligation, going to Hilary's point, around people being required to act in a better way. There is an accountability piece in respect of employers can't simply say, they're not our employee, therefore not our problem. You are going to have to be taking steps to ensure that your employees are not exposed to those individuals. There is one last question on probationary periods, which doesn't really fall within third-party harassment, but we can deal with it just in respect of how to manage probationary periods prior to, as a result of, no doubt, the reduced qualifying service from January 2027. Fundamentally, as yet, there is no strict guidance in respect of what you should be doing, but inevitably what you should be doing is making it very clear what standards are expected, having an audit trail in respect of an assessment of that process, and most importantly, I see it way too often, I'm sure Henry Sophie do too, putting in a very strict time limit so that the probation period, depending on how long it is, doesn't inadvertently flip you over into a period where somebody accrues an unfair dismissal right and then inevitably has the right to claim that, whereas now they wouldn't do so due to length of service. Hilary, Sophie, do you have any other comments on that point before we close off?
I think it's just worth being mindful that from the 1st of July, anyone starting from the 1st of July, once they hit the 1st of January and that length of service reduces to 6 months, they will automatically have 6 months service at that point. So it's not something you want to wait for January 2027 to look at. You want to be looking at that now in advance of July. And
I'd actually say apply a 5-month probation period from July, because otherwise you have the potential risk you sit on it gets to Christmas, people don't want to do it, and they inevitably get their statutory notice for a week. Perfect. Thank you everybody for joining. Have an excellent day, and we'll see you at the next session.
Thanks all. Bye.